Assalamualaikum and hi. We we will be today we will be discussing about the task given on the second week of lecture on suggestions to be implemented in order to improve the working and functions of the ICJ. So the scope of the reforms we will cover, which are five. The first one is judges' independence and impartiality. The second one is the judges' selection. The third, states' consent to establish courts jurisdiction. Fourth, intervention in non-legal matters. And the last one is ICJ's leadership in international judicial settlement of disputes. So for the first point, I will be focusing on the judges' independence and impartiality. So as we know, judges need to be neutral. All agrees with that, but there are a variety of distinct problems behind the single term impartiality that need to be disentangled, where judges must be open-minded about the truth, where they must make factual conclusions only on the basis of the evidence provided by the parties, and they cannot express an opinion on the facts until deciding the case. So when they abandon this kind of neutrality, for example, by announcing that the defendant is guilty before the trial begins, is simply incorrect. So the main factors that are relevant to promote and uphold the independence of the judiciary can be identified on the basis of the first one is the procedures of appointment and promotion of judges. So recruitment and pro, promotion recruitment and promotion procedures of judges need to be taken seriously among states. For instance, in recent years, measures have been taken to make the judicial selection process more open and more participatory, or even to seriously restrict the power of the executive to nominate a judicial officer. For instance, in England and Wales, the Constitutional Reform Act of 2005 instituted a modern system of judicial appointments that departs from a long-standing tradition. And previously, the Lord Chancellor had legislative, judicial, and administrative duties, including the management of a government agency with responsibility for the courts and for judicial appointments. So next, wait. Uh, the, so the Constitutional Reform Act may replace this system with the establishment of a judicial appointment commission, mainly composed of high-ranking judges, which limits the position of Lord Chancellor to one of accepting or exceptionally refusing his recommendations with cause. Next, for Judicial Council, in some nations, all members of the council are appointed by political forces, and in these cases, the connection with politics is stronger, and in other words, this should be improved. Where this can be done by making the councils to have the role of a new major actor, the judicial associations by organizing the electoral participation of judges. Where in some nations, different union like alliances tend to be split along cultural and political lines. And next, in terms of financial autonomy and court administration. So in order to improve courts efficiency, some states can establish specific independent agencies such as court services that composed of judges, representatives of the court staff, member of the bar, experts in the field of management and finance, and sometimes the Minister of Justice, whereas they need to be generally entrusted with far-reaching powers in the area of court administration and court management, and often involved in setting the budget of the justice system, also monitoring expenditures, promoting automation, elaborating criteria for evaluating the overall performance of the courts, and manage to varying degrees, such as judicial personnel. like training, role assignment, evaluation, and promotions in order to safeguard judicial independence. So that's all from my point. The second point will be uh, explained by Najira. Thank you.
Okay, so my name is Najira Binti Roslan. Matrix number is 051307. So I will be talking about the judges selection and the recommendations to improve the working and functions of the ICJ. So, the recommendations that I would like to include that the members of the council, I mean the number of the members of the judges should be elected as individual persons who enjoys the full confidence of all states. The number of members should be increased, and the judges should not only represent the principal legal system, but also special system as well as speak to legal cultures. The composition of the court be made more equitable by increasing the number of judges. New seats be allocated to judges from developing countries and to make the court more representative by considering the re-election principle and allowing a single term. The number of African judges to be raised to five, even if this would mean an increase to the number of members of the court. If the number of judges is to be increased for the further development of the distribution, then in practice, raising the numbers to at least 25. Prudent expansion to a maximum of 18 judges is to be done only if the large volume of cases submitted to the court made such an increase necessary. The composition should be improved. The number of judges should be increased in proportion to the projected expansion of the court's role. More adequate representation is needed, and the composition is not viewed very favorably. So, other than that, in terms of age, composition, and duration of judges, although the issue of composition of the court is one of the most interesting and important issues, there has not been any discussion on the um, during the anniversary regarding the adjustment or increasing the number of members of the judge. I mean, of the court, numbers of members of the court. Sorry. Nor there has been a discussion on the age and duration of service of the judges. The average age of a judge since 1971 has been 60 years, while the average age of a judge who has been elected for a second and third term in the office has been 67 and 69 respectively. Uh, Out of the judges, six judges have served beyond the age of 80. 22 judges have served beyond the age of 75, and 36 have served beyond the age of 70. And the list goes on. Uh, and then Another point is the background of judges and previous roles in the court. This issue can be considered closed and is unlikely to be open in the future unless there is a drastic imbalance as far as the background of the member are concerned. And that's all from me. Thank you. And now we will be continuing to Nurul on the state's consent to establish court's jurisdiction.
Hi, my name is Nurul Athirah Bt Azmi and my metric number is 0507 and 17. So my suggestion for the state consent to establish court jurisdiction is to remove or not making it compulsory jurisdiction in legal dispute. Um, the state provides that a state may recognize as compulsory in relations to any other state accepting the same obligation and the jurisdiction of the court in legal dispute. Such cases can be brought before the court by means of written application. The nature of legal dispute in relation with such compulsory jurisdiction may be recognized as listed. And an international legal system should be resolved and cannot be imposed, should not be imposed as a top down, because it is all depends on whether state are willing to give an external force such as an international court or tribunal the power to judge whether they have complied with their obligation. um, State consent to jurisdictions should serve as a barometer indicating fluctuation in state support for the international legal system. For example, in October 2017, to Burundi withdrew from the International Criminal Court (ICC), raising concern about the effects on the ongoing ICC investigation into allegation to severe human rights abuse in Burundi. And it should be uh, the UK modified the condition under which it accepts the jurisdiction of the International Court of Justice (ICJ), which seems aimed at evading dispute regarding its compliance with the Treaty on the Non-Proliferation of Nuclear Weapons. That's all from me. We move to the next presenter, Fatihah. Thank you.
Okay. My name is Siti Fatihah Binti Zain. My matric number is 051008. For that is the first point, suggestion with regard to the implemented in order to improve the working and function of the ICJ. The suggestion for the intervention in non-legal method, that the issue of the justiciability. For my opinion, in order to improve the working and function of the ICJ with regard to this matter, I think they need to establish a provisions which is the rule and the regulation to control the intervention matter. Maybe they can clearly state that in the provision where to what the extent that the intervention can be faced or occur from certain cases. This thing can be referred to the in the Nicaragua case where the state of US interfere in the ICJ proceeding. Because of the interfere by the US, this has raised uh, some of question with regard to the justiciability. So for this matter, I think we should have the rule and regulation to prohibit the permanent members of UNSID from interfere in the ICJ proceedings. So we need this so we can control the matters, and that's all. So I pass to the next presenter, Nurfazreen.
Hello, my name is Nurfazreen Alia Binti Zawazi. My matric number is 049945. So I will talk about the ICJ leadership in international judicial settlement of dispute. So my suggestion for improve the function of ICJ is, as an international court, the ICJ should improve their role in control the state behavior. This is because many criticism on this court uses the court as an ineffective player in achieving international peace and security, largely because of its perceived inability to control state behavior. Next, the weakness of the court is consensual jurisdiction. So, to make it clear about the function and working of ICJ, the court should tighten the consensual jurisdiction and make a few rules for this jurisdiction. This is because with the weaknesses of the consensual jurisdiction, the state can withdraw their consent, and their rejection of Article 2 often gives their consent meaningless. Okay, that's all from my group. Thank you.